Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. I am still in New York. I'm trying to get out of New York. I'm trying to get this apartment packed up. There's a bunch of ex and current presidents in New York right now making life hell, which is super fun. Um, go away, all of you. Now, and that's not partisan. All of you, all both walks leave immediately. Um, I had a super bad stomach bug this week. It's going around New York. It was not fun. But let's jump into it. Let's get a question answered here. We have a YouTube user Yo Cannon or Yo Channon who asks us, I have a question. Currently, I am approximately 1 month out from my first meeting with the EEOC. I'm very confident in my case, and I'm considering moving forward alone for the time being, at least until the possibility of potentially hitting a roadblock in mediation happens. My case is against a popular chain restaurant with racial, religious, disparate treatment discrimination with adverse retaliation. My question is, should I go ahead and seek counsel now heading into my interview? Or is it okay to seek counsel at the moment mediation potentially stalls? Listen, if you're going to ask me if it's okay to seek counsel later, of course it's okay. Um, it's your life, it's your situation, it's what you've been through. So I'm not going to tell you if something's not okay. If we were family sitting at the dinner table, I would be telling you to hire an attorney right now, because the attorney's fee is not going to change, right? The attorney's going to charge whatever the attorney's going to charge, and that's going to be potentially a piece of whatever they win for you. Some attorneys charge something up front, some attorneys don't. Um, but that's generally not gonna. They're not gonna say, "Oh, well, you did a bunch of stuff and then you hired us, so we'll charge you less." They're gonna say, "You did a bunch of stuff. We're gonna have to redo a lot of it, so we're gonna charge you the same," right? No offense. I'm sure you're doing a great job. That's not what I mean. It's just they're gonna have a particular way that they want to do things with your case, right? So again, if we're family at the dinner table, I'm like, listen, hire this attorney now. It's the same. It's the same cost. Let them add value. Let them reduce risk. Let them work all the way through. And I'll say this: if you're at mediation and mediation stalls, they're not going to stop mediation for you to go get an attorney. Settlement negotiations can certainly continue, but mediation will end, right? They're going to say, okay, mediation's over. Everybody go home, or everybody log out of Zoom, whatever it is. And mediation's over, and you weren't represented, and they treated you like a pro se litigant, which means they offered you, pennies on the dollar of what the case might have been worth, in my opinion. Just my opinion. And listen, of course, I have reasons to want you to hire attorneys. Like, people are going to point out in the comments down below that, like, I have a profit motive as to why I think you should hire an attorney. But I'll note here, you're not going to hire me. You're going to hire a local counsel wherever you are, right? So, as much as I'm telling you to hire an attorney, I'm telling you to hire someone who's not me. And at least, I think that kind of degrades the profit motive argument for me. But I do think you'd be better off with an attorney. I do not think pro se litigants are taken seriously. I think pro se litigants are often viewed as people incapable of going on to litigation, which gets them, pennies on the dollar in terms of their settlement. I think that pro se litigants have different levels of ability, and yours, judging by what you've written here, is very high. But that being said, they will be treated negatively by defense counsel. Many defense counsel don't like dealing with pro se litigants, even really astute pro se litigants. Many defense counsel have horrible experiences. They tell stories about from their experience with pro se litigants. So they come to these interactions very shy, very very nervous, and it's not always the best environment for the best settlement. Um, and you might think like, oh, they're going to be nervous, so I'm going to get a better deal. It's not really the vibe. It's more like they just don't want to talk to you, and so they might just figure they'll try to beat the case at litigation because you're not going to have the ability to fight it in the same way somebody who's well versed in fighting these claims might, right? Um, that's my take. Listen, I get why you would want to wait because you might be able to settle the case without paying an attorney at all. I fundamentally understand that. The counterpoint to that is you might get pennies on the dollar, or you might engage in some behavior that harms your case in the meantime. And you can fairly easily transform a case with a real significant value into a steaming pile of junk in a matter of moments if you're not careful. Just the reality of the situation. You seem very astute, you seem very sophisticated, but you don't do this every day of your life. So you're walking a bit of a tightrope where you could easily harm the value of your claims. You could introduce risk, and you do seem to kind of note that, you know, if settlement negotiations falter later, you would hire the attorney. Maybe the compromise here is you engage in a first round of negotiations, like you extend the demand, whatever your demand might be, and see what the employer has to say. And if things don't seem to be proceeding towards some kind of resolution, then it's time to hire an attorney, right? I don't know if you need to wait to your mediation to hire that counsel. Yeah, just a thought. My gut is always get the attorney in as soon as you can. I get very mad at law firms like, call us after your EEOC. There's so much that can be done, prior to the right to sue letter being received to increase value, reduce risk. Like, it drives me nuts when firms just go around telling claimants, call us when you have your right to sue letter. Wow, you are just skipping the first 3 rounds of a 9-round fight. And you're just picking up your client wherever they ended up and hoping for the best. 3 rounds in, the wild to me. I don't understand it from the law firm's perspective. And the counterpoint to that for you, which I've already kind of said, they're going to charge you the same. The charge is going to be the same. I know you're hoping not to pay an attorney at all, which I feel you on. Trust me. But the sooner the better. The sooner the better in terms of hiring an attorney is what I would say, which is a bit of a party pooper stance. I know, like, I would much rather be like, well, see what you can get. It won't matter. It'll be fine. But I can't really say that in good conscience. So it is what it is. I guess we'll wrap it up here. If this was helpful, like, subscribe, comment down below. Help share our channel so it can grow. And in parting, I really wish these presidents past and present, I guess not future, would get out of New York. That would make me, I mean, maybe there'll be future. I don't know. Who knows? We don't know who's going to get elected. I guess. All right. Take care, everybody.